Let's talk trademarks. Let's talk trademarks and this whole viral demure situation. Come in the building. Trying to get my microphone set up. Let's talk trademarks. The viral demure, mindful, classy trademark. Someone filed a trademark for it who was not the original creator. So we're going to talk about what do you do, legal remedies. Legal remedies, when somebody try to steal your trademark, what the heck do you do? I'm gonna let y'all come in here for a second. I'm trying to get my microphone set up. And let me know if you guys can hear me. I see people joining. Put in the chat if you can hear me. Please let me know. Otherwise, I'm about to just start talking and I guess y'all can hear me. Ain't nobody saying that. All right. So at this point, I'm sure everybody's, at some point or another heard about the trending phrase, very demure, very mindful, very classy. So that particular content creator made a video not too long ago basically talking about someone filing a trademark for that phrase and basically trying to one-up him and steal, his brand, right? Because that particular phrase has been going viral. It's been trending everywhere. He's been getting famous off of it. People have been wanting to partner with him because of this phrase that he's coined or whatever. And so, we're going to talk about what do you do, legal remedies. Legal remedies when someone tries to steal your brand. All right. So I made a video earlier basically addressing a portion of what do you do when it comes to IP when someone's trying to steal your brand. And basically what I talked about was a phase during the trademark process called publication, okay? And you guys have to understand that filing a trademark application is a very lengthy process to get approved by the USPTO, okay? So it's not just you file the application and you automatically own that particular trademark. That's not the way it works. So once you file the trademark, you have to get vetted and evaluated by the USPTO, and they have to determine that your trademark can be registered, right? So they have to approve it. And not until they actually approve it and it's registered do you legally own it, okay? So in this case, the content creator who created Very Demure and all that, he's kind of up in arms right now because he just found out somebody filed a trademark for his phrase, right? So part of the trademark process is a period called publication. There's a publication period. And, during this period, the United States Patent and Trademark Office, they pretty much let anyone in the world challenge your trademark application, okay? And so, if I'm the content creator who created Very Demure and this happened to me, I'm going to immediately figure out how to squash that trademark application. And one of the ways that you do that is to challenge it during publication, And so that is an option when somebody tries to steal your brand. So you don't have to necessarily, thank you for the rose, you don't have to necessarily get defeated just because you see that someone filed a trademark for something. If you know you have superior rights to the trademark in the sense that hey, you were using it before the other person. You have evidence and proof to show that you've been using this particular trademark way back when, right? And you know for sure, hey, the other person, they just trying to steal my brand. They haven't been using this. Then yes, challenge their trademark application during publication. All right. So thanks for the roses. Thanks for the roses. That's a likely scenario in this case for very demure. I would hope that that content creator gets with the trademark attorney and, you know, challenges that person's application. I believe the person who filed the application, his name is like Jeff Bates or something. He's trending right now too. People are kind of pissed off at him for trying to steal this guy's brand. But that's also a very good point of why it's so important to be proactive and protect your brand from the beginning, you know? So very demure, very classy, mindful. That's been trending now for about, I say at least 2 weeks, you know? So the moment that it started trending and that gentleman realized, hey, this is going to be a part of my brand now. This is what people are remembering me for or identifying me from, you know, just like with McDonald's, their slogan, ba 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 ba, I'm loving it. That's how people identify McDonald's. So as a content creator, when he realized, hey, I'm going viral because of this phrase, he should have immediately filed the trademark. Immediately, right? He should have immediately filed a trademark. Now, it takes quite a while for the trademark to get approved. It can be anywhere between 9 to 12 months because, like I said earlier in this live, it is a pretty lengthy process to get your trademark approved. However, you can never go wrong going ahead and initiating the process and filing the trademark. You can never go wrong with that. So if I was that content creator, that's something I would have done immediately. And for many of you guys out there as well, when you coin a phrase or you realize that you're going viral for something that you said, when you start a new business, when you name your company, whatever it is that's going to be attached to your particular brand, you want to immediately file a trademark for that to start the process of you gaining ownership. And the easiest way to think about trademarks and kind of make it make sense is to think of it like a house, okay? Unless you have some type of paperwork for the house, whether that's a lease, allowing you to occupy the space for X amount of time, or legally owning it with a deed, you can't tell somebody to get out that house, that property. You also can't rent that space out, you know? So if somebody went ahead and secured a lease on that particular property or purchased that property and got the deed before you, you know, you kind of, you know, shooting yourself in your own foot. So always think about your brand in the same way that you would look at a house. You would make sure you dot your I's and cross your T's. You would close on the property, right? You would submit your filing, your fees and stuff like that for the property, your closing fees. Everything that has to do with the house is analogous to the trademark, right? When you file your trademark application, that's analogous to you kind of making a bid on the house, right? You sending over a proposal, okay? And the USPTO is going to evaluate your proposal and let you know if they accept it. Same thing with a house. And once you get that trademark registered and approved, you then legally own that particular trademark. So then you can treat it just like you would real property. You can tell people to get out of your house. Hey, you can't use my trademark. You can send them a cease and desist. You can also license it out. You can license it out to people and say, hey, pay me money to use my trademark, right? Same thing with the house. You can tell people, hey, pay me and you can stay here. So with that being said, you know, not to beat a dead horse, but it's always very vital that you protect your brand, okay? And the other thing I wanted to talk about with this whole very demure thing is that, thank you guys for joining. Hi. Let's say you don't meet the timeline or the deadline to challenge somebody's trademark on publication, okay? Because with the USPTO, you only have a certain amount of time, like a certain window in someone's application process to challenge it, okay? And it's typically between like 1 or 2 months or whatever. Let's say you missed that deadline and let's say the person's trademark actually gets registered. Okay. One of the other things that we do at my office is you can file what's called a petition to cancel their trademark. Okay. But this wouldn't happen until the application actually got registered. So that means they got approved for that trademark. If that were to happen, and you missed the publication deadline, then you would file a petition to cancel their trademark. Okay, so that's another option for the content creator who created very demure, very mindful, and all that. He can challenge it on publication. He can challenge it after it gets registered, which I don't understand why he would do that, but it's still a tool in his tool belt. He can challenge it on a cancellation after it's registered. And then the other thing is, heck, the trademark likely won't even be able to be registered with this other person because there's a lot of different requirements to get something trademarked. You can't just file a trademark and then they approve everybody's trademark. It doesn't work that way, okay? And I'm glad it doesn't work that way because just imagine how many people would be stealing other people's stuff, trademarking it, how many people would have redundant phrases and things like that. It just would be crazy out there. So one of the requirements, you guys can leave comments, questions in the chat about trademarks or whatever. If you have questions about trademarks, I'll be happy to answer. But one of the requirements to get your trademark approved is you have to be able to show that you're using that trademark in commerce. Okay, meaning you're holding that particular trademark out in some type of way where you're making money or you're offering a product or a service for money. Whether you made any sales or not, it doesn't matter. But if you're offering some type of product, service, if that trademark is tied to you in any way when it comes to making money. So if you're a content creator, your tag name on TikTok or whatever, if you're in the creators program or if you're making any type of money in any way on TikTok, then you'll be able to show, hey, I'm using this in commerce. But that is not as easy as it sounds. So a lot of times when people file trademark applications, they're not able to meet that burden. Okay. And then if you can't meet all of the requirements for the USPTO to approve your trademark, they will reject it. Okay. So with this very demure trademark, it's a strong likelihood. As a matter of fact, let me pull out my computer. We're gonna do some research together on this live. It's a strong likelihood that the guy, he's not using this in commerce. He's probably at the last minute, he's probably trying to scram and come up with something to try to use it for. But we're gonna pull up the actual application and take a look at it. Because we're very demure, we're very mindful. We do thorough research. I'm surprised you guys aren't asking me any questions. That's crazy. Usually when I'm on Instagram and Facebook, they blow up my comments with questions about trademarks and all that stuff. So again, we're talking about the viral phrase, very demure, that content creator who created and coined that phrase just announced that someone is trying to steal the phrase and they submitted a trademark application. And so we're talking all things trademark, what to do when somebody's trying to steal your dang on brand. So we're gonna get online right now. I wanna look up this particular Jeff Bates is his name, who's trying to steal the very demure phrase. We're gonna talk about it. Man, y'all ain't asking no freaking questions. That's crazy. So let's see what the guy who's trying to steal very demure, let's see what he actually filed on his trademark application. Y'all, I just got back from the gym. I was rushing because I posted on my Facebook and on my Instagram that I was going to go live at 8 o'clock. So I wanted to make sure I was on time. So I had went to the gym, came back, got cleaned up. All right, so let's dive in a little deeper on this particular very demure trademark. And then while we're waiting, I'm going to go over also the essence of a trademark, because surprisingly, a lot of people still don't understand what's trademarkable, what's not, and all that stuff. Which, funny story, I just came home from Chicago, and when I went home, that's my hometown, Chicago. When I went home, I'm at my dad's house, and one of his long-term best friends stopped by. And of course, you know, when you come in town, everybody always come by. They want to see you, party with you, you know, lay eyes on you, all that good stuff. So my dad's one of his best friends stopped by, and he wanted to talk intellectual property with me. And he's like, Candace, you know, I want to do a copyright because I come up with phrases all the time and I want to copyright them. And so it was just cute to see him try to articulate to me intellectual property, but he really didn't understand, you know. He didn't understand what category, you know, things fall into as far as intellectual property. But he was trying. So when it comes to intellectual property, always remember that is an umbrella phrase, okay? And under that umbrella, there's 3 different categories of intellectual property. You have trademarks, which is, you know, what we're talking about today with very demure. You also have copyrights, and then you have patents, okay? And so we're going to start with trademarks because that's what we're talking about today. Trademarks is what you will use to protect your brand, okay? So anything associated with your brand, whether it's your business's name, whether it's your slogan for your business. And it doesn't just have to be a business. It could be if you're an entertainer, a performer, and you have a stage name. Whatever you do, and if you have some type of brand in any capacity, whatever is associated with that brand, how your customers, how the public identifies your business, you as an entertainer, you as a content creator, whatever role you play, how people identify you. And so a lot of times as performers, content creators, you guys have tag names on social media. That's a part of your brand. That's how people identify you. A lot of people have certain slogans that they say when they start their videos, right? Those slogans are also a part of your brand, okay? And obvious, if you have a business, your business name. If you have a logo, your logo, right? Anything associated with your brand is what you want to trademark so that you legally own it. All right. And then, you know, it gets even fancy, more fancy when it comes to colors. So you can trademark certain colors, right? Now that's a very challenging thing to do because you have to meet certain requirements. Obviously, people can't just be over here owning certain colors. But think about the jewelry company Tiffany's, okay? They have a trademark for the Tiffany blue, okay? So anything associated with your brand is what you want to trademark, okay? So that way you legally gain ownership over it, and there's no confusion in the marketplace about what person I'm going to do business with, what content creator I'm trying to go and watch, right? You own it. So you can put a stop to other people using your brand. You can also leverage your particular trademark, your brand, for other people who want to pay you to use it. You know, that's why, like in movies and stuff. Man, my internet's taking forever. What the heck's going on? That's why in movies and stuff, you never really see them have a water bottle with the label on it. Okay? They'd have to pay that water company to have that water bottle in the movie, right? So that is trademarks. You can also trademark a sound, right? So one of my favorites is the Law and Order. When Law and Order first comes on, that little intro sound, that's trademarked. So any sound that's also associated with your brand, you can trademark it, and you should. So that's trademarks, right? And we'll get back to trademarks in a minute with this whole very demure situation. But then also under that intellectual property umbrella, you have copyrights. And I always, look at copyrights as works of authorship. Anything that you can put your name on as an author, whether it's a book, a course, some type of choreography, anything that you can slap your name on as an author, that is what you want to copyright, okay? It could be a painting. You could create some artwork, whatever. Those are the things that you want to copyright. Sounds simple, right? And then the last component of intellectual property is patents. And patents, that's going to protect your inventions. So when you come up with a new invention, I used to always use the example of the flying car. But I saw last year that somebody went ahead and created the flying car, or at least it's in like mock-up stages. I don't think it's open to the general public to purchase yet. But anyways, I'm still going to use that example. When they came up with the invention to create a car that also levitates and flies, that's a new invention, okay? So they would have had to go and get a patent on it to secure their ownership over it. Sorry, if I don't know you, I'm not going to let you join because I'm trying to be focused. Make sure y'all help me out with this video. Give me some likes, things like that, so other people can see this video and learn about intellectual property, learn about how to protect their brand. All right, let's go uspto.gov. So if you ever want to go and search for a trademark, if you have a trademark and you want to check up on it, all you got to do is go to uspto.gov and go to trademark search, and you can search. Now, as an attorney, I can tell you it's not always that simple. So if you're thinking about doing a new trademark, there's additional steps you should take outside of searching the USPTO's website, just because you want to be more thorough when you're filing a new trademark, more thorough to see if anyone out there has already trademarked something, yada, yada, yada. All right, so now we're back on very demure. We want to see this Jeff Bates guy. We want to see his trademark application. So I found it. The application was filed on August 20th. So 4 days ago. And let's go to the actual breakdown of the application. And so the phrase that they filed a trademark for is very demure, very mindful. And so they filed a word trademark. And Jefferson Bates filed the trademark application. they talking about within the one month they gonna publish it. They lying. It don't take no 1 month to be published. That is listed as 2019, before COVID. Listen, after COVID, the USPTO started taking forever to process trademark applications. Now, the average time that the USPTO takes to process an application is between 9 to 12 months. Okay, let me get back to the application. I was checking out some stuff. All right, so this very demure, very mindful application, trademark application, it was filed 4 days ago. It's filed under the class for advertising and networking, yada, yada, yada. So class 35, and it's also an intent to use application. And so there's a couple of things here with this trademark application. There's about 45 different trademark classes when you file an application, and you have to choose which class you're going to file your application in. And you only own your trademark in the category or class that you get approved for, okay? So it's very few exceptions to that. But for example, let's say you file a trademark for a phrase in clothing and apparel, and you get that trademark register, you own it. Well, if somebody else uses your phrase for, class 3 cosmetics, they have not infringed on your trademark because you don't own the trademark in class 3. You don't own your trademark in cosmetics, okay? So it's really important to make sure you file your trademark in the correct category, and also file it in as many categories as you feel like you're currently using that trademark and that you're going to use in the future. So if you sit down with me and you say, hey, Candace, I want to use this particular phrase for clothing and apparel, but next year I also want to come up with the cosmetic line, then I would say, okay, so we need to file a trademark for both of those now. Now that segues into the filing basis. The section 1B is what this very demure application has. So you can file a trademark application saying that you're using that trademark right now, right? You have all your proof ready to go, and that's section 1A. Or you can file it in section 1B saying, hey, I'm not using it right now, but I do intend to use it, okay? Now, before the government is going to approve it, you would have to submit your proof that you're using it in commerce, all of that stuff. So this particular application for the very demure, it's in 1B. So they're basically saying, hey, I'm not using it right now, but I intend to use it. And that's going to be very good for the original content creator who coined that phrase, because that right there in and of itself could be used as evidence to show that, that the original content creator has superior rights to this particular phrase, because he's admitting in his application that he's not using this trademark yet, but he's intending to use it. Whereas the original content creator has already been using it. It's all over social media. He already has a ton of proof that he's been using this particular phrase. So that's good for him. Man, I wish it was a way to record this, because this is some good information. I want to break this up and put it on my YouTube. The other thing with this particular very demure and all that stuff, there's also other applications. Well, before this phrase went viral, there's other applications for the word demure by itself, okay? So another issue that this, content creator could come up against is the person who trademarked the word demure by itself, and let's see, because I just pulled it up. Let's see what year they trademarked this. So the word demure by itself was trademarked in August 2014. Okay, so 10 years ago. So that person who owns the trademark for the word demure, they own it in clothing and apparel. So, let's say that the TikTok content creator who came up with very demure, and if you guys know his name, tell me his name, please. So I'm not constantly calling him the content creator. But let's say he tried to start putting his phrase very demure, very mindful on a t-shirt, right? This other guy who trademarked the word demure back in 2014 could potentially come after him and say, hey, no, even though your trademark has additional words to it, the very essence of it is demure, which is infringing on my trademark. So that could end up in a big battle as well. However, I do think that the content creator has a strong chance of defeating any challenges like that because of the additional components that they have, right? Because I believe the phrase is very demure, very mindful, very classy or whatever. So it's like a whole bunch of extra stuff to distinguish it, if you will. So that's another piece of this puzzle. There is a registered trademark from 10 years ago for demure. So it'll be interesting to see this guy that tried to steal very demure, Jeff Bates. It'll be interesting to see how the USPTO responds to his application that was just filed 4 days ago. Will they reject his application because they think it conflicts with the demure trademark from 10 years ago, right? It'll be interesting to see that. Now let's see, do we have, so far I only see one. I see another registered trademark for the word demure. It is for cosmetics, class 3. We were just talking about cosmetics. So there's currently 2 registered trademarks, including the word demure. Let's see when this one was registered. This one was registered in 2015. So let's see if it's anything involving entertainment. So remember, with very few exceptions, you only own your trademark in the category that you file and get approved for. There's 45 different categories that you could apply for, okay? So, okay, so that's it. There's no more demure. So it's only those 2 that I see that are actually registered. So now that this phrase has gone viral, you never know. Those 2 people who registered demure in cosmetics and demure for clothing and apparel, let's see how they respond to demure being viral right now, because they might start sending out some cease and desist letters if, demure starts showing up on cosmetics or demure starts showing up on clothing and apparel, So that'll be an interesting battle to look forward to. So right now, my thought process as an attorney is, obviously I already talked about how the original content creator can challenge this Jeff Bates guy filing the trademark for his phrase, very demure, very mindful. He could challenge it at the publication phase. He could also challenge it on a petition to cancel the trademark if it gets registered. But another thing I see here is that this Jeff Bates guy, he only filed a trademark in category 35, okay? And that's for advertising, marketing, promotion, stuff like that. Which was clever. It was clever, right? Because when you're a content creator and you're doing promos for other people, obviously right now with that being a trending phrase, people want you to use that when you're promoting their products or whatever, So that was clever. However, he slipped up because if it were me, I also would have filed a trademark in the category for education and entertainment, because the very essence of being on social media as a content creator is entertainment. So let me see what's this guy's name, because you guys ain't put nothing in the chat yet. Let's see what the original content creator's name is. I want to say it's Jason. Invite Estina. Hi, Estina. Let's see the original content creator's name. So if I was him, I definitely would file a petition to cancel Jeff Bates' trademark application for trying to steal his phrase. At the same time, I would file my own trademark application in category for education and entertainment. Because being on social media, that's entertainment. So Jeff Bates kind of slipped up on not filing in entertainment. All right. Let's see what this guy's name is. Jules LeBron is the content creator's name, who came up with very demure, very mindful. So Jules LeBron, if I was him, I'd smack down this Jeff Bates trademark application and challenge it. And then I file my own trademark for advertising, but also education and entertainment. I wonder why he hasn't made a move yet, which is crazy. So let me know if you guys have any questions about this whole debacle with this guy trying to steal very demure and all that stuff. Hi, Mark. Hi, John Burns. Let me know if you guys have questions, comments in general about trademarks. Because I got time today. We got time today. I'm trying to get this orange open. Yo, tell Jules LeBron, tell him, look, my firm will help him out because I don't understand why he hasn't filed his own trademark. It's been trending now for a couple of days. He's known for a couple of days that this other guy has went and filed a trademark for his phrase. I wonder why hasn't he done anything yet? That's crazy. What's going on? And what I realized too is a lot of times people are, this is all new for them. Intellectual property and the business side of being a content creator, the business side of being an entertainer, the business side of having a brand. People just, it's new to them. So I get that. But, since COVID, everybody named mama has learned about intellectual property from being on social media. Because us attorneys, we're on here, we're talking about it. And literally every other day, there's something in the headlines or the news talking about, celebrities fighting over trademarks. So I'm still a little surprised that this guy didn't file his trademark immediately and why he still doesn't have a trademark pending. Invite as a live guest. And so I saw a video with this guy, Jules LeBron, and he was like pretty much crying when he found out about this pending trademark to basically steal his brand. He was crying about it. And so it was very heartbreaking to see. But have no fear. You got options. Smack down that trademark application. And file your own. Very demure, very mindful. It's too much money to be made to be playing for him not to have his trademark filed. And so, all right, let me write this down because I'm gonna have to do another video. Somebody else just filed a trademark application yesterday for the word demure for games. Okay. For a card game. A freaking card. Somebody just filed a trademark application just yesterday for the word demure for a card game. Baby, you can't let nothing go viral on the internet. If baby, you got to move fast and get your stuff trademarked. People not playing. People are not playing. They like, man, we want a piece of this demure. All right, so you got the dude Jeff Bates filed for class 35 on August 20th. For advertisement. And then you got 2 trademarks already registered for demure from 2014 and 2015 for clothing and for cosmetics. So I'm gonna stay up on this because this is gonna be an interesting fight. I feel like people gonna be duking it out in court. My man just texted me and tried to distract me. All right. Well, that's the demure debacle. Demure debacle. All right, folks. Y'all not asking questions and stuff like that, so I'm about to end my live. But if you want to stay up to date legally on what's going on with this whole demure trademark fight or whatever, I will be covering it, especially with this new information. So you got 2 people right now who filed trademarks for demure recently within the past 4 days. One on the 20th, one on the 23rd. And shoot, I feel like at this point, it's going to be more people filing for the word demure. So that content creator, Joel's, he needs to go ahead and file his application and not play. He going to be fighting a lot of people. Okay. All right, beautiful people. I hope y'all have a good night. And remember to file your trademarks so that other people can't steal it, okay? Assert your ownership and stay tuned. there's gonna be more videos about this whole demure thing. All right. Good night. Let me see if I can download this. I'm very demure, very mindful. All right, good night, guys.